Hi, my name's Tony Hadden. I'm one of the partners in Brodies Employment team. With a team of over 20 lawyers dealing with more than 200 employment tribunal claims in a normal year, we're well placed to consider the implications of the current government's proposed significant changes to the system of employment regulation and, importantly, the resolution of disputes arising from it, much of which is proposed to come into force during the remainder of this year. These are, in some cases, radical changes to the employment tribunal system, and all UK employers will be affected by the reaction both of employees but also professional advisors working in the area. I would like to touch on some of the more important changes now. Some changes were made to the employment tribunal system in 2012, and these have crept into current practice relatively unnoticed. Employment judges regularly sit alone in unfair dismissal cases. This reduces the administrative burden of coordinating busy diaries, but does remove the benefit of an industrial jury determining concepts such as reasonableness. The maximum deposit order increased to £1,000 and the maximum expenses or costs order to £20,000. Generally, these changes should result in a speedier and more efficient disposal of claims, and that is to be welcomed. With the continuing pressure on all advisors to provide services at highly competitive fee rates, every aspect of the system of resolving employment disputes needs to be examined to ensure that unnecessary and sometimes unaffordable work is not carried out. Having looked at the changes that have been implemented already, there are further significant changes coming. The most significant of these is the introduction of the fee regime. This will radically alter the principle that the employment tribunal system is free to use. The impact on claimants and the volumes of claims generally cannot be accurately predicted, but it seems obvious that if you have to pay to access a service, you're less likely to do so than if the service is available for free. While the government indicates that the introduction of the fee regime is not designed to reduce the number of claims received by the Employment Tribunal Service, it seems to us that that will be an inevitable consequence of the fee regime. It may, however, result in claims becoming more difficult to resolve. Once a claimant has skin in the game, they may feel that they have little to lose by continuing to litigate where otherwise they would be content to walk away. In addition, service providers will mimic the position in the personal injury field and devise innovative funding structures to help meet the fees, which may again mean that it's more difficult to resolve a claim without the respondent employer making some form of payment. The proposed fees are split into two sections. The first fee, known as an issue fee, will be due when the claim is submitted. That is currently proposed to be £160 for money claims, such as unlawful deduction from wages, and £250 for unfair dismissal or discrimination claims. In addition, there will be a hearing fee due 4 to 6 weeks before the hearing, £230 for the money claims and £950 for level 2 or unfair dismissal claims. The prospect of having to pay over £1,000 to have your claim heard may mean that there's an attractive settlement window shortly prior to the point at which the hearing fee is due, particularly in level 2 claims. The government's assessment is that over half of the claimants in the system will be able to claim some form of remission against the fees, and 26% will be entitled to have their fees met in full by the state. The Enterprise Bill also contains other changes. The compensatory award for unfair dismissal is proposed to be capped at 1 year's pay, or the current cap of £74,200. In 2014, there will be a compulsory period of pre-claim ACAS conciliation. This is proposed to be a 4-stage process, involving the claimant sending information to ACAS, ACAS forwarding that to a conciliation officer, and the conciliation officer then attempting to promote a settlement within a month's prescribed period. If settlement is not reached, the claim can proceed to a tribunal. The government estimates that this process will result in 12,000 fewer claims being lodged, around 6% of the total number. The pre-claim conciliation process will stop the clock in relation to the strict time limits for bringing claims, and given that no fee is payable for the pre-conciliation service, it may allow both parties to resolve relatively straightforward disputes prior to any financial outlay being incurred. Conversely, some respondents may wish to test a claimant's mettle by waiting to see whether they will actually pay a fee before deciding whether to settle the claim. The final area of change results from a review of the Employment Tribunal rules by the former President of the EAT, Mr. Justice Underhill. He has proposed, and the government has accepted, that ET1 and ET3 forms used to respond to a claim be altered. Perhaps more significantly, there will be an initial sift stage, as there currently is in the EAT, at which a claim can be bounced if it does not meet minimum requirements. Again, this is to be welcomed, although it may disproportionately impact on claimants who find it difficult to express themselves through forms and written language. The irritating distinction between CMDs and PHRs will be removed, allowing employment judges to make decisions which are currently only possible at PHRs at the new preliminary hearings. The practice of many judges to encourage parties to use ADR will be formalised in the rules, and the judiciary will be encouraged to manage hearings by imposing time limits on oral evidence or submissions. This is not a significant change from the practice of many existing employment judges, but formalising these powers in the rules will reduce the possibility of parties appealing against the imposition of such orders. Mr. Justice Underhill's proposals and the revisals to the rules of procedure seem to us to be eminently sensible and should result in many of the aims of proportionate management of the caseload, robust dealings with weak cases, and simplified procedures being achieved. As if all that were not enough, there are other employment law-related changes proposed for 2013. The radical renaming of compromise agreements as settlement agreements should take place in the summer of 2013. While this is not a significant change, the proposals relating to evidence regarding pre-termination settlement offers in ordinary unfair dismissal proceedings not being admissible, save where there is improper behaviour, are likely to result in a new line of jurisprudence, cutting across the old established principles of privilege and without prejudice. Following a long battle through Europe, the 2-year unfair dismissal qualifying period will be removed where the dismissal is or relates to an employee's political opinions. Uncomfortably, this may provide protection for those whose opinions are found by the majority to be distasteful, such as membership of the BNP, but that may be part of the price of living in a democratic society. The government had proposed to remove rights from employees who became shareholders. This is currently scheduled to happen in autumn 2013, but there are a number of practical difficulties which may not be overcome by that date. Areas where UK employment legislation goes beyond that required by Europe are being pared back. The old 90-day collective consultation period, where an employer proposes redundancies for 100 or more people, has already been reduced to 45 days in April 2013. The government is currently consulting on amending the working time regulations, which have been a source of significant outpourings from every corner of Europe since their inception. The service provision change and the TUPE regulations are likely to be repealed, bringing the UK regulations back into line with the Acquired Rights Directive. Interestingly, in other areas, the government is proposing to increase employee rights through proposed new shared parental leave provisions, allowing up to 50 weeks leave to be shared between parents following the birth or adoption of a child. Fathers will be given a right to take unpaid leave to attend 2 antenatal appointments, and the right to request flexible working is to be extended to all employees, whether with dependents or not, provided they have 26 weeks service. From our own perspective, we know that flexible working requests often lead to litigation, and it's interesting that the government is proposing to extend this right in an era when the direction of travel appears very much to be simplifying and reducing the so-called administrative burden of employment legislation on employers. Finally, as if that were all not enough, there is the prospect of an independent Scottish government, which would then acquire powers to regulate Scots employment law separately from that of the rest of the United Kingdom. There are already proposals for a Scottish income tax, which will require employers to operate different tax systems to employees in different parts of the UK. And whatever the outcome of the referendum on 18 September 2014, it looks likely that further devolution will be granted to the form of government sitting in Holyrood. Whether that includes increased powers to regulate the employment relationship north of the border remains to be seen.